Okay, let's jump right into this explainer. Because today, we are unpacking a truly bizarre neighborhood dispute out of Scottsdale, Arizona, and it completely flips the usual script on homeowners associations right on its head. Now, most of us are pretty familiar with your typical HOA conflicts, right? You paint your house the wrong shade of beige, or maybe your fence is a half-inch too tall. But this particular administrative law case, it is a fascinating look at contract interpretation, legal strategy, and honestly, a rather shocking procedural misstep.
I mean, seriously, ask yourself, would you ever take the time, the energy, and the money to sue your HOA for not charging a fee? It sounds totally counterintuitive. I mean, most people fight tooth and nail against rising HOA costs or those awful, unexpected special assessments. But a homeowner named Joseph DeBenedictis actually took formal legal action specifically because a fee wasn't being collected from his neighbors.
So let's set the stage here. In 2012, this highly unusual petition landed at the Arizona Department of Fire, Building, and Life Safety. On one side of the ring, we have our petitioner, Joseph DeBenedictis, and on the other side, the respondent, the Sunrise Desert Vistas Property Owners Association.
And what is the grand prize they're fighting over? Well, the entire dispute basically boils down to a single number, $400. You see, deep within the community's governing documents, their CC&Rs, Paragraph 4G mandated an initial regular assessment of $400. Now, both sides absolutely agreed this paragraph existed, but they went to war over exactly how to read it.
It's a classic clash of interpretations. DeBenedictis insisted that the rules required the HOA to collect this $400 fee every single time a parcel was transferred to a new party, so essentially a perpetual transfer fee. But the HOA, they argued that the word initial meant exactly that, initial. They claimed the fee was only meant to be collected when a parcel was first transferred from the original developer. In fact, they argued that continually charging it would literally violate their own CC&Rs.
Now, to truly understand the sheer weirdness of this conflict, we have to look at the crucial backdrop of what happened just a year prior. In March 2011, the Superior Court of Maricopa County dismissed a completely different lawsuit between the HOA and another homeowner, Grace Filliette. And get this for irony. Grace Filliette was actually the president of the HOA, representing them in our current 2012 hearing. Anyway, as part of that 2011 settlement, the HOA legally agreed to stop assessing any further $400 initial regular assessments. They promised not to collect it against any past, present, or future association member. So the HOA had quite literally just settled a lawsuit by legally binding themselves to stop collecting the exact fee DeBenedictis was now petitioning them to collect. Unsurprisingly, things escalated rapidly. DeBenedictis filed his petition in late February 2012. The HOA fired back with a total denial in March. By June, a notice of hearing was issued, which officially locked them into a legal showdown set for September before Administrative Law Judge Tammy L. Eigenhier.
So at this point, the stage is set for an epic legal showdown over the strict textual interpretation of a contract, right? I mean, who is right about paragraph 4G? Well, prepare yourself for an incredible anticlimax, because this entire contractual battle was totally derailed by a massive procedural oversight. The judge's decision ultimately came down to a fatal lack of evidence on the part of the petitioner.
The judge wrote this in her decision. Assuming arguendo that petitioner's interpretation of the CC&Rs is valid, petitioner failed to present any evidence to establish that a parcel in SDV had been transferred to a new party. Okay? Do you see what happened here? The judge didn't even need to decide who was right about reading the CC&Rs, because even if DeBenedictis was 100% correct that the fee should be charged on every single transfer, he completely forgot to prove that a transfer had actually taken place since that 2011 settlement. He brought absolutely no proof that a specific parcel was sold and that the HOA then failed to collect the money.
It is absolutely vital to understand how impartial legal frameworks actually operate here. Now, DeBenedictis pointed to the 2011 settlement as proof that the HOA intended to never collect the fee again. But here's the catch. Intention is not the same as a violation. The judge plainly stated that while the settlement might be evidence of the HOA's possible future actions, it did not establish an existing real-world violation of the rules. The legal system requires a concrete grievance. Judges cannot and will not rule on hypothetical scenarios or possible future violations. You simply cannot sue someone for a rule they haven't practically broken yet.
And honestly, this specific failure in the DeBenedictis case serves as a brilliant masterclass in a much broader, essential legal standard that governs all administrative disputes like this, the burden of proof. This highlights the massive difference between fighting over what a rule means versus proving someone actually broke that rule. Whenever you bring a claim against another party, whether it's your neighbor, a local business, or your HOA, the responsibility does not lie with them to prove they're innocent. The burden rests entirely on your shoulders as the petitioner to prove that they are guilty.
This perfectly illustrates exactly what was missing in that hearing room. The standard of proof here is called a preponderance of the evidence, which in plain English just means providing evidence that is simply more convincing than whatever the opposition brings, basically showing that your claim is more probable than not. But because DeBenedictis brought exactly zero evidence of an actual property transfer, he provided zero weight to his argument. You cannot meet the preponderance of evidence standard with thin air.
Think of a legal claim like a simple three-step puzzle. Step 1, formulate your argument about the rules. And hey, DeBenedictis did this well. But Step 2 requires actual physical evidence that a violation occurred in the real world. He skipped this entirely. And without Step 2, reaching Step 3, satisfying that burden of proof, is mathematically impossible. Skipping the facts will sink your legal case every single time, no matter how eloquent your contractual argument might be.
So, with the burden of proof entirely unmet, the narrative of this case comes to an abrupt and decisive close. Administrative Law Judge Tammy L. Eigenheer concluded that the petitioner simply failed to establish that the respondent violated the CC&Rs. Her recommended order was crystal clear. No action was required of the HOA, and the petition was officially dismissed.
Just tracing the final bureaucratic wrap-up of this dispute shows how these decisions are formalized in the system. The judge transmitted her decision electronically on October 2, 2012. The Department of Fire, Building, and Life Safety then had a statutory window until November 6th to accept, reject, or modify her ruling. Well, the department took no action. So, by operation of law, on the very next day, November 7th, 2012, the judge's dismissal was formally certified as the final administrative decision. The HOA was clear, and that $400 fee remained uncollected. Ultimately, this case is such a vital reminder that in the eyes of the law, just having a really strong opinion about the rules simply isn't enough. You have to ground your arguments in tangible reality. So I'll leave you with this final provocative thought to consider the next time you find yourself tangled up in a neighborhood debate. If you ever got frustrated enough to actually take your own HOA to court, would you remember to bring the hard evidence to prove it? Thanks for joining me on this explainer, and keep asking the right questions.